All right, well, we'll go ahead and start this afternoon. I'd like to thank everyone for attending. My name is Seth Zirkle, attorney here in Evansville, Indiana, with the firm of Condees, Donovan Kahn. I head up the lawyers chapter based in Evansville, Indiana. I'm very happy today to extend a warm welcome to John Malcolm to present SCOTUS Roundup 2022 term and provide his insight and analysis on what might be called pivotal cases to watch for this term. In fact, today, if you've been watching, oral arguments are going on one of the so-called affirmative action cases there are a number of developments. And so it's going to be a very prescient presentation by Mr. Malcolm. Mr. Malcolm oversees the Heritage Foundation work to increase understanding of the Constitution and the rule of law. As vice president of the Institute for Constitutional Government and the director of the think tanks Edward Meese Third Center for Legal and Judicial Studies, as well as the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow. In addition to his duties at Heritage, Mr. Malcolm is past chairman of the Criminal Law Practice Group at the Federalist Society and also serves on the board of trustees of the Washington National Opera and the board of directors of the Legal Services Corporation. He is also with the Boys Town, provides service to Boys Town, Washington, D.C., which provides homes and services to troubled children and families who are edging towards crisis, and the Barber Family Foundation, which dispenses college scholarship funds to children of deserving veterans. Before joining Heritage in 2012, Mr. Malcolm was general counsel at the U.S. Commission on International Religious Freedom, as well as a distinguished practitioner in residence at Pepperdine Law School. From 2004 to 2009, Mr. Malcolm was executive vice president and director of worldwide anti-piracy operations for the Motion Picture Association of America. Mr. Malcolm is a graduate of the Harvard Law School and holds a bachelor's degree in economics from Columbia College. Born in New York City, he grew up in Tenafly, New Jersey. He and his wife, Mary Lee, currently reside in D.C. They have two adult children, Andy and Amanda. And as I'm sure Mr. Malcolm is aware, Village of Tenafly, one of the great religious free exercise cases, and the Orthodox Jewish community, prescient as ever with the rapper or the performer formerly known as Kanye in the news and whatnot. But anyways, every time I see Tenafly, New Jersey, I think, the era of... Anyway, without further ado, take it away, sir.
Well, thank you, Seth. It's a pleasure to be with you, at least virtually. We have a lot to cover since I was asked to cover sort of the last Supreme Court term and something about this term. So let me get right to it. So last term was truly remarkable, not only in terms of the opinions that were issued. We had an unprecedented leak of a draft majority opinion, picketing, which continues to this day outside of the homes of the Republican-appointed justice, and an attempted assassination of one of the justices, Justice Brett Kavanaugh. Originalism had probably its best year on the court, and certainly its best year since the days of the Warren Court era. The court considered a number of important constitutional cases, and the split in most of these cases was 6-3, with the quote-unquote conservative justices in the majority and the three quote-unquote liberal justices in dissent. In the biggest case of the term, Dobbs versus Jackson Women's Health organization, a 5-justice majority ruled that the Constitution has no right to an abortion, and it overturned Roe versus Wade from 1973 and 1992's Planned Parenthood versus Casey. A 6th justice, Chief Justice Roberts, would also have upheld Mississippi's Gestational Age Act, which banned most abortions after 15 weeks, but he would not have overruled Roe or Casey. Nearly 50 years ago, Justice Byron White, in dissent in Roe, wrote that the ruling in Roe represented, quote, an exercise of raw judicial power. Many legal scholars, including pro-choice liberal scholars, agreed with that assessment. John Hart Ely said, for instance, that Roe was, quote, not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, the Watergate prosecutor, said Roe reads like a set of hospital rules and regulations, and that neither historian, layman, nor lawyer will be persuaded are part of the Constitution. Even Lawrence Tribe said, quote, even if there is a need to divide pregnancy into several segments with lines to clearly identify the limits of governmental power, interest balancing of the form the court pursues fails to justify any of the lines actually drawn. And radical liberal legal scholar Mark Tushnet referred to Roe as, quote, a totally unreasoned judicial opinion. Those views were all reflected in the majority opinion in the Dobbs case. It was written by Justice Samuel Alito. Alito noted that virtually every state outlawed abortion, often with criminal penalties attached, in 1788 when the Constitution was ratified, in 1791 when the Bill of Rights was ratified, and in 1868 when the 14th Amendment was ratified. That history was also made it very clear that the right to an abortion was not deeply rooted in the nation's history and tradition, nor was it implicit in the concept of ordered liberty. That was the test that the Supreme Court had previously adopted in 1997 in Washington versus Glucksberg, when deciding whether to recognize a liberty interest as being one based in the Constitution. Justice Alito wrote in the Dobbs opinion that, quote, the term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. Indeed, most states still prohibited or limited abortions in 1973 when Roe versus Wade was decided, and no state had held prior to that time that the right to obtain an abortion existed in their state's constitution. The majority, and many judges since then, were not able to articulate which provisions of the Constitution were implicated, although most courts seemed to eventually settle on the proposition that this was a liberty interest that was implicit in the due process clauses of the 5th and 14th Amendments. In 1992, in Planned Parenthood versus Casey, the court, by a 5-4 vote, didn't even attempt to defend Roe or its viability framework. Instead, it created a new and completely nebulous undue burden standard, and then just called on people to accept the court's decision. They clearly did not, as abortion came to dominate every Supreme Court confirmation hearing and most political races, which is happening today in advance of the midterm elections. The fact that 26 states asked the court to overturn Roe in the Dobbs case was a sign of just how deeply unpopular that opinion was in many states, and the residents in those states had certainly not accepted Roe. Alito also cited to dozens of seminal cases, including many that are celebrated by people on the left, in which the court had overturned prior precedent. Alito added, without these decisions, American constitutional law as we know it would be unrecognizable, and this would be a different country. In terms of other substantive due process rights that the court had found, Alito pointed out that abortion is different, in that every abortion kills an unborn human being, which even the majority in Roe had recognized. Having failed in the courts, abortion rights proponents are now going to have to do what they always should have been required to do, and that is to convince their fellow Americans that they are right. Interestingly, in a concurring opinion, Justice Thomas suggested that the court should reconsider all of its substantive due process cases. That caused quite a stir in newspapers around the country, although I would hasten to add that none of the other justices on the court joined his concurring opinion. The court also decided an extremely important Second Amendment case, New York State and Rifle and Pistol Association versus Bruin. Justice Thomas wrote the 6-3 majority opinion, striking down a New York law that required law-abiding citizens who had already passed a background check to demonstrate a special need beyond just a general desire to defend oneself before being permitted to carry a firearm outside of the home. The court said that such a restriction was not supported by either the amendment's text or our nation's historical traditions. The court made clear that the Second Amendment right to keep and bear arms extends outside the home, and that the state could not impose a proper cause or special need requirement because before issuing a permit to a law-abiding citizen who passes a background check. Since Heller in 2008 and the McDonald case in 2010, Thomas noted that lower courts had adopted a two-step approach to analyzing the constitutionality of gun control measures. First, a court would analyze whether the law regulated activity within the scope of the Second Amendment as it was originally understood. And second, if it did, the court would then apply either intermediate or strict scrutiny, depending on whether that law or activity burdened a core right under the amendment. The Bruin majority rejected that analysis and said it was, quote, one step too many, holding that the only inquiry a court should make is whether a regulation is consistent with this nation's historical tradition of firearm regulations. Thomas also noted that this history and tradition is used for other types of constitutional claims, citing to cases involving, for instance, the Confrontation Clause and the Establishment Clause. Thomas further stated that the amendment was, quote, the product of an interest balancing by the people, and that it was improper for a court to engage in, quote, judge empowering interest balancing inquiry once the protections of the amendment had been properly invoked. Quoting from the Heller decision, Thomas said, constitutional rights are enshrined with the scope they were understood to have when the people adopted them. Last term was also quite a year for adherents of religious liberty. In Kennedy versus Bremerton School District, the court ruled in favor of Joseph Kennedy, a high school football coach who lost its job after violating an edict from the school that he stopped praying at midfield after football games, which is something that he had done for many years without any complaints from anybody. Kennedy did not directly encourage anyone else to pray with him, but he didn't stop them either. At times he would be at midfield praying alone, and at times others would join with him. Kennedy used to offer locker room prayers after the game that incorporated religious references as part of a motivational speech to his players, but he had, and this was undisputed, stopped that practice when the school asked him to do that. After he was fired, Coach Kennedy sued the school district, claiming that it had violated his rights to free speech and free exercise under the First Amendment to the Constitution. The school district responded by arguing that since Kennedy was a school official on school grounds, people could form the mistaken impression that the school was endorsing his prayers, thereby converting his private speech to government speech, which would violate the Establishment Clause. The lower court, which had sided with the school district, relied extensively on a 1971 case, Lemon versus Kurtzman, in which the court established a three-part test for analyzing Establishment Clause cases. In that case, courts are supposed to analyze whether the law in question had a secular purpose, whether its principal or primary effect was to advance or inhibit religion, and whether the practice in question, whether in practice the law in question would foster excessive government entanglement with religion. Lemon had long been criticized by judges and academics who argued that this was not a particularly helpful test and could lead to whatever result the judge wanted. Justice Scalia had once described the Lemon test as, quote, some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. But, he added, quote, such a docile and useful monster is worth keeping around, at least in a somnolent state. One never knows when one might need him. In a 6-3 decision by Justice Gorsuch, the court sided with Coach Kennedy, holding that the district's actions had violated his free exercise and free speech rights. In the first paragraph of his opinion, Gorsuch stated, quote, the Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression, for religious and non-religious views alike. He stated that teachers, like students, do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, and added that a school does not endorse private religious speech simply because it fails to censor it. He also noted that right after the games, the practice was that coaches were free to attend briefly to personal matters. They could go talk to friends or family members or check their telephones, and that the school was wrong to single out Coach Kennedy because he used that time to pray silently. The majority also held that properly understood, the free speech, free exercise, and establishment clauses, all of which appear side by side with each other in the First Amendment, are meant to complement each other, not compete against each other. Significantly, in terms of the Lemon test, the majority stated that, quote, this court long ago abandoned Lemon and its endorsement test offshoot. In truth, although Lemon had often been ignored by the High Court, it had never been formally abandoned. The fact that the court has now officially declared Lemon to be dead is a big deal, and it will have a big impact on future cases. The court said, in place of Lemon and the endorsement test, the Establishment Clause must be interpreted by reference to historical practices and the original meaning of the Constitution. This, of course, is exactly what the court did in the Dobbs case and the Bruin case. The court acknowledged that some people would likely see Coach Kennedy or others like him praying and then might be offended by that. But taking offense is not the same as coercion, and the court added that learning how to tolerate speech or prayer of all kinds is part of learning how to live in a pluralistic society, a trait of character essential to a tolerant citizenry. There were other big religious liberty cases last term. In Carson versus Macon, the court said that a state cannot prohibit parents from using state funds at religious schools so long as those funds are part of a generally available tuition assistance program. The court stressed that Maine didn't have to have a tuition assistance program, but that once it decided to offer one, it cannot disqualify private schools from receiving any of those funds so long as a decision is made by the parents, simply because those private schools are religious. In Shurtleff versus Boston, the court held that an organization could not be denied a permit from flying its flag in the plaza by City Hall simply because the flag conveyed a religious message. And in Ramirez versus Collier, the court held that a condemned prisoner was entitled to have his pastor pray over him and place his hands on him as he was being executed, so long as those practices did not disrupt the execution. And it was also a very big year in terms of curbing the excesses of the administrative state. In NFIB versus OSHA, which was a case involving whether the Occupational Safety and Hazard Administration had the authority to implement a private employer vaccine mandate. In West Virginia versus EPA, a case involving whether the EPA had the authority to essentially phase out greenhouse gases under the Clean Air Act. And in Alabama Association of Realtors versus HHS, a case involving whether the Centers for Disease Control and Prevention had the statutory authority to implement a nationwide eviction moratorium. The court, again by 6-3 votes in each of these cases, invoked what has come to be known as the major questions doctrine and held that the separation of powers principles requires Congress to speak clearly before an administrative agency consisting of unaccountable bureaucrats can exercise nearly unlimited power over decisions of great, quote, economic and political significance. So now let me move on to this term. While I really doubt that it's going to be possible to top the drama of last term, from my perspective, this term is indeed still shaping up to be very, very significant. In a pair of cases that are being argued as I am speaking, the North Carolina case just finished its argument. The Harvard case is going on now. There are two cases, Students for Fair Admissions versus Harvard College and Students for Fair Admissions versus University of North Carolina, in which the court is being asked to reconsider and overturn both the 1978 decision in Bakke and the 2003 decision in Grutter versus Bollinger. You could also include the second Fisher case from 2016 if you want. The challenger in both of those cases is a nonprofit group representing students and parents that have sued both Harvard and University of North Carolina, alleging that their race-conscious admissions programs that primarily benefit Black applicants and largely at the expense of Asian American applicants, that they violate both the 14th Amendment in the case of University of North Carolina and Title VI in the case of both Harvard and University of North Carolina. And here are some of the evidence that they presented during the trials. So for instance, assuming all else being equal in terms of similar credentials, an Asian American with a 25% chance of admission to Harvard would see his or her chances rise to 35% if he was white, 75% if he was Hispanic, and 95% if he was Black. At Harvard, African American and Hispanic students with a PSAT score of 1100 or higher are sent a letter and are invited to apply to Harvard. But if you are white or Asian American, you need to score at least a 1350 on the PSAT before you receive such a letter. Harvard's admissions data also reflected or revealed, and University of North Carolina, by the way, has similar data, astonishing racial disparities in admission rates among similarly qualified applicants. For instance, they did a test that showed that if you were an Asian American in the bottom fourth out of five, they said they were deciles, I think they're quintiles. So you fell somewhere between 60 and 80% in terms of applicants, not your top 20%, not 20 to 40%, somewhere between 60 and 80. If you were Asian American, you had virtually no chance of getting into Harvard. You would have a 0.9% chance of getting into Harvard. But an African American in that quintile actually had a higher admission rate than Asian Americans in the top 20% of applicants. The schools in both cases say that, oh no, race is just part of a holistic process that they use, which is what Grutter called for, and that race is simply used as a plus factor. The schools assess applicants on other characteristics such as kindness and character and likability, and whether an applicant has a positive personality. At both schools, Asian Americans would score very poorly in these other intangibles, and African Americans would score off the charts in terms of these other intangibles. This, by the way, is the same kind of holistic practices that Harvard employed during the 1920s and 1930s, and it was used to keep out, for the most part, Jewish students because they felt that there were too many Jews attending Harvard College at the time. The challengers, as I say, assert the University of North Carolina is violating the 14th Amendment, that's state school, and also Title VI of the Civil Rights Act, which prohibits discrimination on the basis of race, color, and national origin for any educational program that receives federal funds, and Harvard is accused of violating Title VI. The cases had originally been consolidated, but the court separated them because its newest justice, Justice Ketanji Brown Jackson, served on the Harvard University's Board of Overseers and couldn't participate. She was recused from the Harvard case, which again, I say is being argued right now, but she did ask questions and she is participating in the University of North Carolina case. In Grutter, the court had held that the University of Michigan Law School's race conscious admissions program did not violate either the 14th Amendment or Title VI, and the court determined that such programs were permissible so long as race was used as a narrowly tailored remedy in order to further a compelling government interest. The court defined that compelling government interest as a need to obtain the educational benefits that flow from a diverse student body. The court said that narrow tailoring in this case meant that the program had to be flexible and non-mechanical, and that it could not serve at what was really a de facto quota system. Further, the court said that school administrators would have to, in good faith, consider race-neutral alternatives in order to achieve that objective before turning to racial preferences policies. The challengers in both the University of North Carolina case and the Harvard case say that this is a pretense and that neither school is doing any of that stuff and that they flunked the tests that the court had established in Grutter. In my opinion, the Grutter was wrong on the day that it was established. So despite reaffirming, as Grutter purported to do, that all racial classifications have to satisfy strict scrutiny, Grutter held that a student body diversity can justify the use of race in its admissions policies. Grutter doesn't have very much support in the 14th Amendment, and in terms of its historical meaning. 14th Amendment doesn't contain any exceptions. It protects any person from denials of the equal protection of the laws. In my view, you ended up having, Justice John Marshall Harlan's sole dissent in Plessy versus Ferguson, in which he stated our Constitution is colorblind and neither knows nor tolerates classes among citizens. That dissent was ultimately vindicated, as we all know, in Brown versus Board of Education, but I believe that it was undermined in Bakke and certainly in Grutter. As Chief Justice Roberts said in the 2007 case, Parents Involved, which declined to extend Grutter to public high schools, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Justice Sandra Day O'Connor said in Grutter, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. That 25 years, by the way, would lapse in 2028. It was very obvious from the North Carolina argument, and I assume it will be obvious from the Harvard argument, that the proponents of racial preferences have no intention of ending their desire to continue using racial preferences in 2028. So we will see how those cases come out, but I think that Grutter is likely to be overturned, if I had to guess. The court's going to hear a significant election law case out of North Carolina, Moore versus Harper. So in that case, the liberal North Carolina Supreme Court, where they're elected justices, and there are a total of 7 justices on that court, 4 of them are Democrats, 3 of them would affiliate with being Republicans. So the liberal North Carolina Supreme Court overturned the congressional map, redistricting map, that had been adapted by the conservative North Carolina legislature following the 2020 census. The North Carolina Supreme Court concluded that that map resulted in partisan gerrymandering. Again, it was a 4-3 vote with the 4 Democrat justices overturning that map. In 2019, in Rucho versus Common Cause, the U.S. Supreme Court had held that partisan gerrymandering does not violate the U.S. Constitution. But here, the state Supreme Court held that the map that the legislature had adopted violated North Carolina's Constitution. Specifically, it's guaranteed to its citizens for substantially equal voting power and substantially equal legislative representation, as well as their right to free elections. Now, mind you, those guarantees have existed in the North Carolina Constitution since 1776. In other words, it has been around for 246 years, and never before has a court found that those guarantees prohibit partisan gerrymandering. The legislature here is saying that the Supreme Court is just reaching out to create a new right because it doesn't like the map that the legislature drew. And so it's found these violations so that it could impose its own map. The justices, the U.S. Supreme Court justices, are going to be asked whether this state court ruling violates the U.S. Constitution's Elections Clause, which is Article 1, Section 4, Clause 4. That provision provides as follows: the manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations, except as to places of choosing senators. This issue is particularly significant because executive branch officials and state and federal judges issued opinions that altered existing election laws and procedures in various states during the 2020 election, using the COVID-19 pandemic as a justification for doing so. And when they made these changes, they made them unilaterally without seeking or obtaining the approval of state legislatures to these changes. In 2020, the justices turned down a request by Pennsylvania Republicans to fast-track their challenge to a ruling by the Pennsylvania Supreme Court that required state election officials to extend the deadline for counting mail-in ballots. When the court declined to hear that case, there was an accompanying opinion by Justice Alito that was joined by Justices Thomas and Gorsuch, in which they suggested that that state court's opinion likely violated the Elections Clause. Now, as I just said, the Election Clause does empower Congress to make or alter such rules, but there's no federal statute that stands in the way with what the North Carolina legislature did here. So if the challengers to a particular election regulation object to it, they have obvious recourse. They can either go to the state legislatures and ask them to change their minds, or they can go to Congress. Either body can provide them the remedies which they seek, but that's not what they want to do. They want to get a state court to, override the federal constitution by coming up with a creative interpretation of the state constitution. It's also worth noting that all of these challenges have been brought by liberal advocacy groups, usually headed up by Mark Elias, and they've done a pretty good job at cherry picking the states in which they are seeking a redress of their grievances. Specifically, they are picking red states that adopt election integrity laws that they don't like, but that happen to have state Supreme Courts that have majority liberal justices on them. When there's partisan gerrymandering that goes on in blue states, they don't have any objections to those. On December 5th, the court is going to hear another significant case called 303 Creative versus Alanis. Lori Smith is a graphic designer from Colorado who wants to expand her business to include wedding websites. She's willing to create graphics or design websites for all people, regardless of their sexual orientations on other occasions, but she does not want to design websites for same-sex weddings because she believes that same-sex marriages run conflicts, it conflicts with her interpretation of God's will. She also wants to post a message on her own business's website to explain that. She has challenged a Colorado law that prohibits businesses that are open to the public from discriminating against gay people or from announcing their intent to do so. This is the same Colorado law, by the way, that was applied against and challenged by Jack Phillips of Masterpiece Cake Shop just a couple of years ago, when local authorities tried to punish him because he refused to custom bake a cake for a same-sex wedding on the same basis, that he believed that it conflicted with his religious beliefs and would be a tacit endorsement on his part of the same-sex marriage. He argued that that violated his free exercise rights under the First Amendment. In that case, the majority of the Supreme Court justices ducked the issue. What they did was they held that the Colorado Civil Rights Commission that considered the matter had displayed an impermissible hostility to his sincerely held religious beliefs, and that he was entitled to have a hearing before a neutral decision maker. In this case, Lori Smith is arguing that she, again, is being forced to tacitly recognize a same-sex marriage or express approval for it, and that she's also being prohibited from explaining why she doesn't want to design this website. The court, I believe, in this case, is going to reach the merits of the issue which they ducked in the Masterpiece Cake Shop case, but with a twist. The justices have agreed to hear Lori Smith's claims under the Free Speech Clause, but they declined her invitation to consider two other issues. One, whether the Colorado law violated her rights under the Free Exercise Clause, and they also declined her invitation to overrule their 1990 decision in Employment Division versus Smith, in which the court held that government actions usually will not violate the Free Exercise Clause so long as they are neutral and generally applicable. I think the odds are extremely high that Lori Smith is going to prevail on her Free Speech Clause argument. The court recently heard oral argument in a case that's going to decide whether the state of Alabama's 2021 congressional redistricting plan violates Section 2 of the Voting Rights Act, which prohibits voting practices or procedures that discriminate on the basis of race. A three-judge panel of federal judges in January had ordered the state to draw a new map with two majority Black districts. The original map drawn by the Alabama legislature had only one majority Black district, claiming that Alabama's map had violated Section 2. The Supreme Court put that ruling on hold so that the Alabama legislature's map could be used in connection with the 2022 midterm elections that are happening next week, but they set the case for oral argument. The Solicitor General of Alabama made a very, very broad argument, arguing that the challengers to the state's redistricting plan should have to prove specific intent to engage in racial gerrymandering. But virtually every justice on the court, including the conservatives, appeared to reject this, noting that Congress had amended the Voting Rights Act to make it pretty clear that they would be able to recognize claims based on a disparate impact analysis. You didn't have to prove specific intent. The Solicitor General's backup argument, and likely his stronger argument, is that the challenger's map was drawn in a way so that race was the predominant factor, which is something that the Voting Rights Act prohibits. And if it was the predominant factor, the court has strongly hinted that this would also violate the Equal Protection Clause of the Constitution. I'm not sure which way that case is going to come out. We will see. The court's going to consider an important immigration case, U.S. versus Texas. So last term, the court ruled in favor of the Biden administration when it sought to terminate President Trump's Remain in Mexico policy. In this case, Texas and Louisiana are challenging a new policy by the Biden administration that prioritizes certain groups of illegal aliens for arrest and deportation. In a September 2021 memorandum, the Secretary of Homeland Security, Alejandro Mayorkas, outlined what the administration's immigration priorities were going to be. He argued in that memo that there are more than 11 million illegal aliens in the United States who are subject to deportation, and that the government simply doesn't have the resources to apprehend and deport them all. The memorandum instructs immigration officials to prioritize cases involving three different categories: suspected terrorists, people who commit serious crimes, and those who were caught at the border. The states that are challenging this claim that they will suffer a financial harm as a result of this policy by, for example, requiring them to keep non-citizens in state prisons for longer than they otherwise would. And they also argue that this policy conflicts with various provisions of the Immigration and Nationality Act. They also contend that the administration failed when they implemented this policy to comply with the Administrative Procedures Act because he didn't provide adequate notice and comment period for the general public, and that they properly failed to consider things like the high rate of abscondment and recidivism among criminal aliens who are facing final orders of removal, and hence it was an arbitrary and capricious ruling on their part. We'll see what the court does. The court recently heard argument in a very interesting case involving pork, National Pork Producers Council versus Ross. And this may actually prove to be one of the most consequential cases of the term. So, as the most populous state with the biggest economy, California has regulations that often have an outsized influence on, if not, the ability to dictate how businesses around the country operate. And this case is a very good example of this. So California, with such a large market, can essentially impose notions of proper standards of production on virtually every other state of the union at little cost to itself. Because nationwide pork producers can't segment, or any kind of producers, can't very easily segment their markets, producers will typically follow what California tells them to do, or they will face the crippling consequence of being excluded from the California market. More moderate states are governed by laws, are as going to, a result of that would be governed by laws that they didn't vote for and that they wouldn't vote for if they had a chance. And the challengers are arguing that such a system violates the postulates of a federal system. So here's the basic outline of this case. Californians consume about 13% of all of the pork that is produced in the United States. But California farmers produce almost none of that pork, 0.13% of the pork, to be exact. Californian voters, though, have a very strong views about the ethical treatment of pigs, at least when other people have to pay those costs. In 2018, California passed Proposition 12, which allows the sale in California only of pork that was produced under very specific conditions that would make it far more costly for any pork producer to comply with. Specifically, that proposition says that the sow that gave birth to the pork that is being sold has to have been kept in a pen that was at least 24 square feet so that the sow could turn around without touching the cage. So for Californians, this is, an easy and a cheap way to virtue signal, because virtually no California farmers would have to bear that cost. But the rest of the country would end up having to pay a lot more for pork. Through their trade association, the pork producers are challenging this, arguing that this restrictive proposition violates the so-called Dormant Commerce Clause of the Constitution. That is a legal doctrine that is inferred or has been inferred by the Supreme Court from the Commerce Clause and is designed to prevent state protectionism. It prohibits legislation that discriminates against or unduly burdens interstate commerce. The Ninth Circuit agreed that this proposition would dramatically increase the cost of pork, but it held that in favor of California. California challengers believe that this law or this proposition poses a grave threat to interstate federalism because, again, it's going to affect how everybody else produces pork and the cost everybody else pays, but not California. And they raise the point that if this stands, the consequences could be dramatic. So no one questions that if the pork was somehow diseased or had trichinosis, that California could do this, but that isn't the case here. And that they argue that if California wins this argument, because they have their own notions about the ethical treatment of animals, what's the next step? Could California prohibit, for instance, imports from companies that don't comply with California's preferred version of ESG regulations? Could they bar the import of products from companies that in the production of whatever exceed California's carbon emission targets? Could they prohibit the importation of goods that are produced by companies that are headquartered in states that ban abortions? These are the kinds of things that the court is going to be asked to address and to weigh in and say, at what point does a state's ruling even violate interstate commerce? Now, to be sure, the Commerce Clause gives a power to Congress. It is not a restriction on what states can do, at least according to its terms. And that has caused some textualist judges and originalist judges to be very leery about the Dormant Commerce Clause. So one justice, for instance, to watch in this case is Justice Clarence Thomas, who in past dissents has said that, quote, the negative Commerce Clause has no basis in the text of the Constitution, makes little sense, and has proved virtually unworkable in application. The court is also going to consider a couple of other cases, which I'll mention before stopping and open things up to questions. One of them is Gonzalez versus Google, and the second is Twitter versus Tomney, that deal with the scope of Section 230 of the Communications Decency Act. And these cases raise the question about whether social media platforms can be held liable for terrorist propaganda that was uploaded by users, but provided to others through YouTube, which is owned by Google, and Twitter's algorithms. In both of those cases, they involve parents of loved ones who were killed by terrorists abroad. Gonzalez's case was an attack by ISIS in Paris, and the other case was an attack by Al-Qaeda, or also, I believe was also ISIS, in Turkey. And they're claiming that jihadis had posted videos that were then disseminated to others who might be interested in such material through the algorithms of Google and Twitter, and that this constitutes a material aid to terrorist organizations. Section 230 of the Communications Decency Act generally provides that no provider or user of interactive computer services shall be treated as a publisher of or a speaker of information provided by another information content provider. This was originally pursuant to a law that was passed in 1996, designed to provide some breathing room for internet service providers in order to provide communications, and it hasn't really been tested by the Supreme Court since then. In a 2020 case, Justice Thomas issued a statement after the Supreme Court declined to grant certiorari in a particular case, and said in an appropriate case, we should consider whether the text of this increasingly important statute aligns with the current state of immunity enjoyed by internet platforms. He has suggested that perhaps internet platforms can be regulated like common carriers. So this is an important case, and lurking in the background are cases out of the Fifth Circuit and the 11th Circuit, sort of a split of opinions. There's appears to be a circuit split on laws attempting to prohibit internet platforms from discriminating on the basis of political viewpoints in terms of the stuff that they will take off of their platforms. One other case I'll mention only because it was just decided by the Fifth Circuit, and the Supreme Court, I think, will have no choice but to take this case. It involves the Consumer Finance Protection Bureau. There was a case involving the CFPB up before the Supreme Court a couple of years ago, the Celia Law case, in which the Supreme Court said that the statutory provision that said that there is a sole director who was not removable by the president except for cause, that violated the Constitution in terms of his removal rights. Instead, in that case, what the court said was, well, even though the statute doesn't say it, we will essentially rewrite the statute to just say the president can remove the CFPB head for any reason if he wishes to. Another unique feature of the CFPB is that it does not get its funding from Congress. It gets its funding as a percentage of funds raised by the Federal Reserve, something over which Congress has no control. And the Fifth Circuit has just said that that funding mechanism violates separation of powers principles because Congress loses the power of the purse and any oversight responsibility for what happens at the CFPB. If that ruling stands, CFPB will cease to exist. And I think the Supreme Court's going to have no choice but to take up that case when a cert petition reaches it. So that was a lot of material. But with that, let me stop and answer any questions that you might have.
I apologize, John. My unit froze up, but I want to thank you for the presentation and the remarks. We have a number of folks with us today. Any questions that would like to be raised? I would ask that, given the numbers that we have, if you might unmute your mic, please state your name and ask the question, which includes a question mark, and then please mute your mic again to allow our presenter to respond.
Okay. Well, hearing no question. Oh, okay. Here we go. Any questions? Well, if I hear no questions, Seth, let me just add that it's been a pleasure being with you. And I look forward, like I know all of you do, to seeing what the Supreme Court does this term.
As do we. Thank you so much for your time today, and thank you all for joining us. As a heads up, we will be hosting Professor Nicole Garnett in December 1st, for a presentation on developments in school choice. John, thank you so much, and a good day and good afternoon to everyone. Thank you.